Welcome to a fresh episode of Legal Wrangle on income tax. We have selected 3 important cases. First, where favourable treatment was given by tribunal by granting an early hearing. Second, where reassessment was framed without disposing of as assessee's objection. And third, where interest on excess refund was imposed prior to insertion of section 234B.
We have always heard of the legal jurisprudence which is justice not only be done but seen to have been done. Similarly, there are other connotations which says that justice delayed is justice denied. The present case which we are going to deal with is an example set up by the writ court which should always be adhered by the judicial forum on being approached. The assessee in the present case is a media personality and the executive chairman of NDTV. Now let's understand what exactly happened in this case. It was the case of the assessee that the Delhi bench of ITAT had passed a ratification order involving him by fixing an early hearing and considering additional documents which were never part of the record, and that too without informing the assessee in an appropriate manner. The department, however, alleged that the tribunal could not be faulted with for fixing an early date of hearing. As far as additional documents are concerned, a reference to those documents was found in other documents placed on record, and hence its maintainability could not be challenged, being an administrative order.
Let's see what was the final outcome of the High Court. Early hearing order passed in favour of one of the litigants without hearing the order is not an administrative order beyond challenge. Here are some key takeaways. The High Court has granted relief to the NDTV and asserted that the department has to move a formal application under Rule 29 of the ITAT procedure rules to justify the bringing on record additional document in its possession. A litigant should be heard by any forum in the manner he has approached, and he should never be preferred over other adversaries from long pending queue unless and until there are justifiable reasons for giving a preferential treatment for hearing him on priority and out of turn basis. Tribunal, being a quasi-judicial authority, should not close their eyes and grant preferential treatment to a party on the verge of making others suffer by terming it as a mere administrative order.
Now let's move on to our second case, where reassessment orders were passed without disposing of the assessee objections. The assessee in this case is a real estate promoter who was served reopening notice believing that his income chargeable to tax has escaped assessment pursuant to nil declaration by him. Now let's understand what exactly happened in this decision. Coming to the background of the case, the department had furnished the reasons for invoking section 147 pursuant to the request made by the assessee. However, without giving disposal to those objections, the ITO had proceeded to pass the assessment order. When this approach of ITO rendered in violation of the law as per the assessee was challenged, the single judge bench set aside the reassessment order and directed the ITO to consider the matter afresh after disposing of the objections. Giving effect to the such directions, the objection raised by the assessee though considered but were overruled without any discussion.
Let's see what was the final direction by the High Court. Failure to carry out procedural requirement of disposal of assessee's objection will not render the very assessment framed under section 143 as void ab initio so as to be not curable. Here are the key takeaways. Revenue officials are not bound to deal with the objection raised by the taxpayer in the reference to the opening if there is no necessity for proceeding with objections. Obligation towards disposal of taxpayer's objection regarding reopening comes into picture only when the AO decides to overrule the objection. The forming of opinion to proceed further by disposal of objection need not to be detailed consideration of all the facts and law applicable. It only asserts to show that there was application of mind to the objection raised by the noticee. if on consideration of objection raised by the assessee, the AO is of the view that there is no ground made out to proceed, he can pass an order to wind up the proceedings. Non-disposal of objection is only a procedural flaw which can be cured by remitting the matter to the assessing authority.
Now let's move to our last case where interest under section 234 was imposed on the excess refund in such a way that the said liability towards the interest always existed in the statute since its formation. Now let's understand what exactly happened in the case. The processing of assessee returns gave rise of certain refunds which was adjusted against its tax dues earlier year. Subsequent to the same, scrutiny assessment was framed wherein after giving a credit of TDS and advance tax, the AO found that the assessee was in arrear of tax. He therefore, while withdrawing the refund already paid to assessee, computed tax payable by assessee as on the date of order of assessment and also processed to calculate interest under section 234B on such outstanding tax liability. Now, the case of the assessee is that neither section 234 nor any other provision of IT Act envisages levy of interest on the amount of refund paid after processing return under section 143, even though later on it was founded that the refund was eventually to be withdrawn upon final assessment of assessee's tax liability.
Let's see what was the final outcome of the High Court. When new section 234B was inserted to address the mischief of missing levy of interest on excess refund granted after processing return under section 143, it cannot be argued that such an interest always existed within the provision of IT Act. Here are the key takeaways. In case where refund is already granted upon processing return under section 143, but in eventual assessment it is found that the refund granted is in excess or that return does not give rise to any refund claim at all, the existing statute does not provide for levying interest. Even the aid of the provision of section 143, the existing provision cannot be so interpreted as to levy interest in such a case of excess refund. While interpreting a statute provision, one of the useful external aid is to ascertain what was the position prior to the enactment of the statute and what mischief the statute seeks to address. Explanation added to section 234D by Finance Act 2012, but with retrospective effect can be applied only to the pending assessments. With this, we wrap up this episode of Legal Wrangle. Next time, we will bring some more interesting cases from the world of taxation. Thank you all for watching. Goodbye.